In a very few special situations, the Supreme Court will listen to an entire controversy instead of exercising its usual appellate role. Superscript 11 reads, these include cases affecting ambassadors, other public ministers, and consuls, and cases between states. Back to the text. Congress has responded to the changing needs of an increasingly technical and litigious society by creating specialized federal courts. These tribunals, which decide nothing but precise, narrow aspects of federal law, have over the years included the tax court, the customs court, now known as the Court of International Trade, the Court of Customs and Patent Appeals, and the Court of Claims, which handled cases filed against the United States. Superscript 12, it reads, in 1982, the new Court of Appeals for the Federal Circuit was given the appellate jurisdiction of the Court of Claims and the Court of Customs and Patent Appeals. Another new court, the U.S. Claims Court, assumed the trial jurisdiction of the Court of Claims. Back to the text. State courts, because the constraints governing the federal courts do not bind the states, the range of issues considered in state courts can be quite broad. The Massachusetts High Court, for example, will issue advisory opinions on important matters of state law to other governmental departments. Unlike federal courts, whose jurisdiction is limited by the U.S. Constitution and the judgment of Congress, state courts entertain all types of cases. Federal claims often wind up in federal court because such tribunals may be perceived as more sympathetic toward federal rights or capable of greater expertise in their application, but state courts possess concurrent jurisdiction over federal matters unless and until Congress says otherwise. The organization of state courts varies considerably. See Figure 1 6, but there are always two or three tiers of general review. The lowest level may share its jurisdiction with subsidiary tribunals that hear only specific types of cases, such as traffic, family, juvenile, or probate matters. States are also free to set the terms under which state court judges serve. Many state judgeships are elected offices, although the judiciary ordinarily tries to hold itself above the political fray. Judicial elections occasionally engender some vigorous campaigning and public debate. 23 of the 50 states have intermediate appellate courts. These courts may be considered subsidiaries of the trial court or treated as separate entities with review by higher tier. Figure 1 4 shows the federal judicial courts. I believe there are 11 districts. And then the United States Supreme Court has three branches. The one on the far left is appeals from state high courts. The middle one is U.S. Court of Appeals for Federal Circuit. Under that, there are various administrative agencies, U.S. Claims Court, Courts of International Trade. Under the third branch, U.S. Courts of Appeal, 12 circuits. There's three branches, U.S. Tax Court, 91 U.S. District Courts, and various administrative agencies. Under the State High Court, there's the Intermediate Appellate Court, the Superior Court, and probate, county, municipal, family, and juvenile. Under County Court, Justice of the Peace, police magistrate.